sign in if you want CLE credit in the back. We're gonna talk until about 1:45, and then we'll have time for about 10 minutes of questions before we will end at about 5 so that people can get to class if that's where they're going. Today we are very pleased to welcome Professor Victor Flatt. He is a distinguished scholar of carbon markets at the University of Houston's Law Center's Global Energy Management Institute. He was previously the inaugural O'Quinn Chair in Environmental Law at the University of Houston Law Center. And he's taught at the University of Washington, Georgia State College of Law, University of North Carolina School of Law, where he was the co-director of the Center for Climate, Energy, Environment, and Economics. He's a recognized expert in several areas of law, including environmental law, climate law, and energy law. He's the co-author of a popular environmental law casebook and has authored more than 40 law review articles. He clerked for Justice Boggs in the U.S. Sixth Circuit Court of Appeals, and this is his first year teaching in the summer session here at BLS. He's teaching environment in the private sector this session, though he was previously here 5 years ago as a distinguished scholar. Professor Flatt's talk today is called Disclosing the Danger, State Attorney Ethics Rules Meet Climate Change, and I hear it's going to be very exciting. So I'm delighted to welcome Professor Victor Flatt. Please join me in welcoming him.
Thank you. I'll try to be exciting. Thank you for the opportunity to be here. I appreciate this the summer workshops and for the faculty who here I know and all the support you've given me. It'll become apparent as I'm speaking what I'm actually talking about. But just to start us, we're grounded in attorney ethics rules. And it turns out that we haven't explored a lot between attorney ethics rules and clients that emit greenhouse gas emissions, and that there's some things that I think should be explored that haven't been explored yet. And you'll have time for questions, of course, and such at the end. So just to start off, it's important to start with some facts about climate change, because this is going to matter. The UN in 2012 estimated that climate change kills over 100,000 people annually in direct causes. And the World Health Organization estimates that even with better solutions to disease vector, that 250,000 people per year will die of climate change by 2030. If you include indirect causes, these causes that are not directly attributable to climate change, to climate change, that number rises to 400,000. Those are things such as extreme weather events, drought, wildfires, heat flooding, etc. And that's from the Climate Vulnerability Index. On top of all of that, the UN estimates that 5 million people are harmed per year by climate change in varying degrees. So I think it's important when we start to just remember that we are talking about something that actually harms people and harms quite severely. And that is only going to accelerate as time goes on. The other notable thing I want to start with is litigation. There's been an expansion in litigation over climate change that continues to this day. By 2018, local governments in California, Colorado, New York, Washington, Rhode Island have all brought tort lawsuits under their respective state laws against energy producers for damages related to climate change. These sound under public nuisance, strict liability, failure to warn, private nuisance, negligence, and trespass, and mixtures of all of those. And there is an issue, one of the main issues in the courts now is whether or not these cases can sound in state court, state law versus federal law, and there's a lot going on with that right now in the cases in California. But the bottom line is what I would call the climate activism bar, and I don't actually have a good name for what it is, but that's what I'm calling it. And if there's an actually accepted better name, then I'm happy to use that. But the climate activism bar is continuing and accelerating. And it's doing that, I think, for an obvious reason. We seem to be stalled politically, at least in the United States, in addressing greenhouse gas emissions and adapting to the impacts of climate change. And so what you see is attorneys using the tool that they know, You know, they're carpenters and they have a hammer. So they're going to use law to try to make a dent in this continued emission of greenhouse gases and the damage that it is causing. All right, well, what does all that mean? Why does it all matter? Why does climate killing people and this climate activism bar being quite aggressive in their cases make such a difference, and what does that mean? Well, I'm going to move now to the ABA Model Rule 1.6b1. Okay, just for those of you who do or do not remember ethics, it'll become familiar as we continue. But the ABA Model Rule is of ethics are generally followed to different extents in almost every state, so I'm going to start with the model. An attorney may disclose information if it is to prevent reasonably certain death or substantial bodily harm. In 2002, there was a requirement that the reasonably certain death or substantial bodily harm be related to a criminal act, but that was dropped from the ABA Model Rule in 2002. We have a variation among the states in this rule, but they can be grouped into sort of three largish categories. 5 states require a disclosure of any client action that could cause death or substantial bodily harm, period. There doesn't have to be any criminal or fraudulent activity. If the attorney knows that the client's action could lead to death or substantial bodily harm, they must simply disclose it. 7 states, including Texas, which is my home state, require disclosure as well, but only if the emission of the greenhouse gas, or I'm sorry, with the client activity, is associated with criminal or fraudulent activity. So you have 12 states that mandate disclosure, and you have 37 states then that permit disclosure. And that varies between whether or not you have to have the criminal or fraudulent element or you don't. It's about half and half. When you mix these, though, with some other ethics rules, some interesting things come up. First, we already know that the attorney herself cannot commit or further criminal or fraudulent acts. That's, if you stop and think about it for a second, non-attorneys, I'm sure, would also get that as well. And the attorney must withdraw representation if a client will not cease in actions that are criminal or fraudulent. But then we also have a companion rule related to these two things that say, in the course of representing a client, a lawyer shall not knowingly, quote, fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. Now we'll go back. That was Rule 1b6. So when you put those two things together, what that means essentially is if you have a client that you know is engaged in a criminal or fraudulent activity, you must disclose that to avoid assisting them unless it's prohibited by 1.6. But as we've seen, all 50 states either require or allow that disclosure. So the bottom line means that if you have any client who is engaging in a criminal or fraudulent activity, that's the maximum bottom line, that would cause death or substantial bodily harm, you must disclose that. So even though some states say may, with operation of 4.1b, it changes into a must if there's criminal or fraudulent activity. All right, so what does this have to do with greenhouse gas situations? All right, I'll look at it with respect to the issue of criminal and fraudulent behavior first. What if you had a client that failed to report greenhouse gas emissions as required by the Clean Air Act? So many of you may know who've had environmental law, if it's made it into your Clean Air Act part yet. Since 2010, the EPA has required major emitters of greenhouse gas emissions to report the amount every year to the EPA. Now, under the Trump administration, and even under the Obama administration, this has not been really pushed or enforced very hard. And what I can tell you is, and you may not know, is that a good half of the major emitters of greenhouse gas emissions have never filed this report. And what's interesting is that the failure to file is considered a criminal violation of the Clean Air Act, Section 114. I'll come back to that. What about failure to report material financial impacts? My class and I have just been having a field day with this about what financial impacts from climate change are material for requirements of disclosure in publicly traded financial corporations. Failure to report these material financial impacts can lead to state common law fraud accusations as well as potential federal securities regulation. And a separate issue is a government attorney. I'm going to come back to government attorneys in a moment. So let's break this down a little bit more, and I'll use Texas as the example. When a lawyer has confidential information clearly establishing that a client is likely to commit a criminal or fraudulent act that will likely to result in death or substantial bodily harm to a person, the lawyer shall reveal confidential information to the extent revelation reasonably appears necessary to prevent the client from committing the criminal or fraudulent act. The key phrases here that I want to focus on are criminal or fraudulent, and remember, there are some states that do not require any criminal or fraudulent element, but the majority of them do. The phrase likely to result in substantial death or bodily harm, and the phrase to prevent that death or substantial bodily harm. In order for an action of a client to meet this disclosure requirement, it has to satisfy all three of these things. So let's start with the crime. As I stated earlier, failure to correctly inventory and report GHG emissions is a crime. It's promulgated pursuant to Clean Air Act 111E performance standard, in sections 113.1 and 14, criminalize any false or omitted statements required by that performance standard. I'll also just mention fraud. There are multiple allegations and investigations of financial reporting violations. The New York Attorney General, Letitia James, has inherited a long-term investigation, the AG of Massachusetts as well, that have been brought against some major energy companies. So the bottom line there is that it turns out that if a client or a company emits greenhouse gases and fails to report it or has made any false, materially false, or omitted any material statement in financial disclosures or committed the state definition of fraud, that comes under the criminal or fraudulent activity. What about the next plug? It's likely to result in death or serious bodily harm. Well, I already started this by showing you that the United Nations estimates that 100,000 people per year are killed by climate change impacts. Now, granted, those are sort of statistical deaths. They're not directly related to, they could be traced to certain people at a certain point, but they may not, they don't, it doesn't sound like the death of a person. Most of you who remember criminal law or ethics probably remember that this ethics rule, if you remember it at all, came up with a situation of where your client is like, I'm going to kill the judge, right? And you're like, I've got to report that client. They're going to kill the judge. And that was the idea, that if you had a client that was going to do this harm, that you had to report that in order to stop the harm. Well, it turns out that in the evolution of this rule, ethics rule, both from the commentary at the federal level and from the majority of states' interpretation, that the person does not have to be a specific person, nor does it have to be at any specific time in the future. It doesn't have to be immediate, either in the temporal sense or it does have to be in a connected sense, but not temporal. So, in fact, the ABA comment on Rule 1.6b1 states that a harm is reasonably certain to occur if it will be suffered imminently, so that sounds pretty immediate, or if there is a present and substantial threat that a person will suffer such harm at a later date if the lawyer fails to take action necessary to eliminate the threat. And if you were to go online or go to the library and look up the ABA rule, you'll see that the example they give is a release of toxic toxic substances into a town's water supply, right? It may not hurt anybody right then. We don't know, but we know that it's increasing the danger of harming people. And we don't know who the people are, but we do know that some people may very well be harmed, that it could be an imminent threat. And so that is the example that they give. Okay, so it turns out, given this very broad definition in state ethics laws about what it means to have a threat of substantial death or substantial bodily harm to an individual, that it doesn't have to be a specific person at a specific time. All right, well then the next term is the term prevent, all right? So that could be something that doesn't seem to fit as well with greenhouse gas emissions reporting as perhaps with other things. So all of the state rules, including the ABA rule, indicate that the requirement to disclose or the allowance to disclose is only what is necessary to prevent the harm. So if you think about the putting or releasing toxic material into the city water supply, the attorney would need to say that in order to stop people from drinking that water, to get the water cleaned up so that in fact that harm would not occur, or to stop that harm from occurring. Or if you're talking about your client that's going to kill the judge, you go to the police in order for them to stop your client from killing the judge. Well, when we're talking about greenhouse gas emissions, particularly emissions from the past, we know that's already occurred, right? So how is it that this does prevent this harm, substantial bodily harm? Well, there are a couple of responses that I want to explore with you. First of all, under the Clean Air Act, a failure to report may be an ongoing violation. And I just note that it may be because the federal courts are split on this question. If it's an ongoing violation, by definition, it is a continuing harm, meaning that the failure of people to even know that this stuff is being emitted or was emitted is harmful to them. But is it that kind of harm, like death or substantial bodily harm? Well, we also know that reporting emissions does encourage fewer ongoing emissions and does encourage mitigation. In fact, many of you may be familiar with the Climate Disclosure Project, whose whole raison d'etre is based on this concept, that requiring reporting of greenhouse gas emissions will always push emitters to reduce emissions going into the future. Anytime you reduce emissions going into the future, you will, of course, also reduce the potential harm there. Now, this all sounds a bit, I'm sure you're like thinking, what? This all sounds a little strange. And honestly, I would just note that this may not be the best or only reading of state ethics rules, but I think it's important to look at it simply because in terms of whether attorneys may or may not face discipline for certain actions, what they should be concerned about is not whether it's the best interpretation, but whether it is a possible interpretation. And I bring that back again to the client activism bar. Right? There are 50 states, there are 50 chances, and it's unclear what and how those cases may be brought. And I'll come back to that. One of the questions I've had when I've thought about this, and I think it's a very good question, relates to issues around causation or level of significance. So when I first did a presentation of this to what in Texas is called the Super Conference, because everything's bigger in Texas, but it's not, don't believe it. So Super Conference for Environment and Energy Attorneys, I was just preliminarily discussing this idea, and I watched 1,000 attorneys' faces go. But they said, well, wait a minute. Okay, so we have a client that emits greenhouse gases. Did you drive a car here that emits greenhouse gases? Do you not contribute to death or substantial bodily harm? Does every single client that drive a car contribute to that, et cetera? It's a good question. And it made me start to think about whether in these attorneys' ethics rules there is some sort of level of significance, right? Is there some cutoff above which you can say the client's greenhouse gas emissions contribute to death or substantial bodily harm, and one say that below that it's more difficult to say, you cannot say it contributes to death or substantial bodily harm? Well, we do know a couple of things about this. So, first of all, given our construct of climate change or climate emergency, we do know that the greenhouse gas emissions must be human-made beyond the natural background carbon cycle. And you can have disputes over what the natural background carbon cycle is, but that means essentially that it has to be additional greenhouse gas emissions that have come into the atmosphere that would not have come into the atmosphere without this significant human industrial intervention. All right, well that's sort of one way you can cut it, because otherwise it's not climate change, it's just climate, right? It's the same. And so you can kind of draw a bit of a line there. It also turns out that the UN does have estimates that accompany their death predictions related to climate change. And using a UN estimate, the standard they note is that 132,500 tons of greenhouse gases would be responsible for one statistical death. 132,500 tons of greenhouse gases to be responsible for one statistical death. That's relating the billion plus tons of CO2 plus their number of potential deaths resulting from it leads to this number. Now, if you're a science person, you could say, yeah, well, okay, but greenhouse gas emissions, it's not an either or. It's statistical. It just goes, right? So you can't have one half of a death or something like that. So what can you do? And that's true. That's true. But I do think looking at this estimate does give us something to think about in terms of a scale comparison. So in 2007, the Scherer coal-fired power plant in Juliet, Georgia, emitted 25,300,000 tons of CO2 in 1 year, which according to the UN would be enough for 190 statistical deaths from climate change. The average automobile in the United States emits about 6 tons of CO2 every year, meaning that an individual car would have to operate for around 22,000 years to cause one statistical death. Now, does that mean that driving internal combustion engine cars is a good idea or that it doesn't contribute to climate change? Of course it doesn't mean that. But it does give you a sense of what we're talking about in the differentiation of scale of greenhouse gas emitters. And so if you look at that, I think there are a couple of lines that can become clear. One, if you can't really even rise to the level of one statistical death, and courts or state Supreme Courts, look to applicable tort laws and that sort of thing and causation, then it's going to be, it's hard to say you need to report your client for driving their car for a year. On the other hand, if you do say that you have a client that does and could be responsible for over 100 statistical deaths, that does, in 1 year, that does start to seem like a large number. Even though we don't know who those people are or where they are, they don't have to be in the United States. It's anywhere, but that matters. Well, is this whole thing even real? All right. What does the future hold about this, and why do I think it matters? I think that one way to think about this is to compare it to a similar concern that was voiced about attorney ethics related to hazardous waste in the late 1980s and early 1990s. At that time, there was a debate of attorneys as to whether or not the substantial death or bodily harm exception to requiring a release of information, whether or not that was applicable to something like hazardous waste. And that debate came up precisely because of the things I've mentioned. Is it supposed to just be one person? Does it have to be immediate? Do you have to be able to identify the person, et cetera? And in response to that, even though there were I think in fact no reported cases, there was some scholarly evaluation of this, and there were some state attorney general opinions about this, all of which led to the ABA's revision in 2002 that clarified that this absolutely did not mean a specific person immediately. In other words, the concept was that yes, if you had a client that committed a crime or fraudulent act, or in the future, or in another version of the law, simply did something that could cause harm or substantial bodily harm, and that was through the release of hazardous waste, that was a requirement to report. Even though you don't know when or how that hazardous waste may cause death or substantial bodily harm, or whether it combines with another thing to cause death or substantial bodily harm, but that it would be swept up in this. So you can see sort of the parallels between hazardous waste and greenhouse gas emissions along these lines of cumulative nature, with, joining with other emitters to cause the harm, undefined time frame, non-specific identified individuals. And so theoretically, this seems to be kind of similar to that. And that is, in fact, what got me thinking about this, because I was reviewing something and I noticed again about this hazardous waste, and I just started thinking about how much it's like that. But as I said, if you go back, there weren't any actual attorney disciplines related to that. Zero, big zero. In fact, there are very few attorney disciplines related at all to this failure to disclose information. There are a couple of examples that are sort of similar to what I'm talking about with the tobacco and tobacco litigation, but very rare. So why do I think that all of a sudden this should be something that we consider and think about as important in terms of greenhouse gas emissions, if it didn't really cause any big distinction with hazardous waste? Well, the reason I think that we must think about it differently is what I started with, and that is climate activism. The big distinction between these two is that we had a fully integrated legal framework for addressing hazardous waste and hazardous waste pollution, et cetera. Meaning that anybody who released without reporting or any of those things would already be subject to criminal activity, and the attorney would be swept in under that way before you get to confidential information or anything else of that nature. And so we have people that were concerned about hazardous waste, of course, and they should be, and they still should be. But we did have laws that were designed to address those concerns. And in fact, the way they're at least normatively designed, they're supposed to eliminate health impacts from these. We do not have that with climate. In fact, we have a sort of opposite situation. And because we have that opposite situation, we have seen this continuous escalation of litigation by any means necessary to try and effect some action to mitigate greenhouse gas emissions or adapt to the harms that it is causing. Again, the most common and most recent have been the nuisance lawsuits, but you can go back. They started, back even with human rights. They started with federal nuisance before that was taken off the table. There's been private nuisance. There's been public nuisance. There are other tort remedies, and as I said, we're sort of on the cusp now of determining whether or not some of these will still be allowed to go forward in state court or not. And you see the major oil companies reacting to this. I mean, they're like, this is completely baseless. We shouldn't be called in front of court. You see judges that are very fearful, I think, of doing some sweeping litigation related to the harms that come from climate change. Many of those judges will even cite issues about standing, right? We don't really, it's not our job to completely, say how much anybody should emit or not emit or anything like that. That's beyond our ken. It's a political question, possibly. Well, what's interesting about attorney ethics is none of that matters. You don't have to have standing. Anybody can file a complaint. You don't have to argue that they're violating a law. The law doesn't have to be enforced. It's just a question of whether there's a law and they're violating it. It doesn't matter whether the authorities are enforcing that law or not, so i.e. the reporting of greenhouse gas emissions. Just as when litigation, there are 50 bites at the apple. There are 50 different states. And if it fails in one state, maybe they'll try it in another state. Many of you who are barred may or may not realize this. I don't know what the percentage is in this state, but a lot of attorneys are barred in more than one state. So for instance, in the city of Houston, 25% of the attorneys that have a Texas license to practice law also have a California license to practice law. Texas and California, as do I think all the states, have a reciprocal agreement on attorney discipline. If someone is disciplined in California, automatically that discipline would apply to the activation under their Texas bar as well. So imagine, if you will, that a climate activist decides, hey, this is worth a shot. What can I lose? I'm going to file an ethics complaint against this person for failing to disclose the emissions that were not reported. And it's going to embarrass them, it's going to force them to do this, and it's going to scare that attorney so much that they're going to try to influence what's going to happen with this client of theirs. And just say 3 states, Oregon, Vermont, and California, let it continue for a moment. Now, certainly a state legislature can come in, and I would certainly expect the state of Texas to, and say this is not an ethics violation, period, doesn't count. State Supreme Courts could intervene, and many of them may say the same thing, this doesn't count or it's not there. But looking at the makeup of state bars and state Supreme Courts across the country, you can discern differences in what they consider to be ethical violations. Not ethical violations, not related to this directly, but I would just note that Oregon is considering a new ethics rule about harm just to the environment generally that attorneys may have to report. Again, just sort of showing what matters. Well, so should every attorney who's ever represented a client that has emitted greenhouse gases be terrified? Maybe, maybe not. What I would actually expect to happen, what I'm starting to hear in the background, is that the first step would be to file a question with the state attorney general to get an opinion on this, just to try to get the clean path forward if there, so you don't have to worry about it. Attorneys are risk averse, and so they want to make sure they're not getting into particular trouble. And attorney general ethics rules are not necessarily binding depending on which state you're in, but it's a good way to start. We also know that we're having a lot of debate nationally at the federal level about, maybe it doesn't seem like a lot of debate, maybe I'm just too into it, about whether we're going to price carbon or not price carbon, and whether as a part of that we're going to preempt litigation or other things, and if that's the case, well, let's throw attorney ethics in there too, or whatever. Of course, that would be a federal reach into a very traditional state power, which would be difficult, but possible. So I don't really know. All I know is that when I have discussed this, and I'm not primarily an ethics attorney, I'm primarily an environmental climate academic. And aside from maybe Irma Russell, there are not a lot of academics who have done a lot of work in ethics and environmental law. But the ethics folks I've discussed this with can find no reason that it isn't a valid theory. And not just here in these states. As it turns out, Canada, Australia, the United Kingdom have similar disclosure requirements, some more lenient even than here. Of course, they all do have comprehensive climate change bills, although Australia goes back and forth on whether it's implemented or not. So my point is, I think attorneys need to be aware. Attorneys that work with companies with major greenhouse gas emissions need to be aware that it's possible that unless their client is following the root and letter of the law, or if they're in these 5 states, whether they're following the law or not, and they're emitting greenhouse gases that cause harm to death or substantial bodily harm, which by definition they do, then they may be under requirements to disclose information that they otherwise might not disclose, or that would be considered confidential client information, and under the pain of an ethics violation. So that's why it's titled Disclosing the Danger. Danger of climate change, but also danger to attorneys themselves. So that's all I have in the presentation. I'd love to have a discussion. Thank you. Pat.
Fabulous. I mean, this is incredible, good scholarship.
Thank you.
Brilliant, courageous, crazy. I think the best name for these climate activists
Planet Saviors, all right. If I use that, I'll attribute it to you. Planet Savers, okay?
So there's tension with attorney-client.
Mm-hmm.
How does that, how would that sugar off? I mean, you put a lawyer in a particularly difficult situation.
Right. I think that's the crux of the question. That's the hub of it. That's what attorneys have to be concerned about. The way I see it is just your run-of-the-mill attorney, naturally averse, would have to say, you know what? Guess what? There's this thing out there that maybe that I have to disclose information that might, that you might be not disclosing or require you to disclose if it's related to climate change, and I'm just letting you know that because I'm not sure how that's going to play out or not. And then you have multiple attorneys doing that. You have companies that are like, wait a minute, are we not going to even be able to get attorneys to work for us anymore? Or is it just simply encouraging them, even just in the most mundane thing, report your greenhouse gas emissions, right? If nothing else, that, because that probably will have a salutary effect moving forward. So that's kind of how I see it. There's a whole different question with attorneys that work for the government.
I was going to ask you about that.
That's almost a whole other paper. Randy, can he add something to that? Okay, all right.
We both can.
Okay.
Just yesterday, I think it was the judge in Maryland, refused to let DOJ substitute new lawyers in the census.
I didn't see that
And
yet.
I thought that was very interesting because there's two explanations. It was, one is the lawyers lost the case, so screw them. Get somebody else who's better. I doubt very much.
I think it's more the attorneys won't do it.
I think the attorneys are saying, I'm not going to
I won't do it. I won't do it because I think it's right, and it's getting to a frivolous lawsuit, a Rule 12b violation. I think that's what they're concerned about, and it is their own. I mean, it is their personal ethics that they are concerned about to me, and that's exactly the comparison.
Government lawyers aren't saying.
So, in fact, one of the things I talk about in the article is the example of attorneys, and I know a bunch of them out of the air policy group in RTP, North Carolina. 65 of them are attorneys. They're barred. These are the people that write all the rules, for EPA on air. And Query, does one of those attorneys, if Trump says, well, the social cost of carbon is $1 at zero, and there's no evidence produced, are they like, wait a minute, that's false. That's a fraudulent thing on the American public. I can't do that. And again, their dividing line would probably be if something would be considered frivolous or not. And by the way, mostly everybody knows, and if you look at ethics rules, representing your client zealously is usually, fine. Any sort of legal theory that's marginally plausible is fine, covered by attorney-client privilege, et cetera. But in this administration, we really have seen sort of something I think we've never quite seen before, which is proposals that are completely untethered from factual or other support. Which, you could maybe get at those through arbitrary and capricious issues as well, but what about the attorneys? What are their roles in that as well? Randy?
Talking about the reporting, your theory would suggest that, I guess where I'm going with this is that, yeah, there's a legal requirement to do the reporting, but what you're really saying is that they've got to reveal these emissions because they are the cause of the harm. So is working for a client that emits more than, I can't remember, 120,000 tons per year, that they are basically aiding and abetting?
Okay, so this kind of depends on what jurisdiction you're in.
Right.
So if you were talking about emitting more than permitted or allowed, and let's say that could be related, or you have permits to do, like in California with CO2 or RGGI or something like that, and there's a criminal or fraudulent act, yes, you've got to withdraw, you would be aiding and abetting, that's a whole other ethics violation. If, though, you're simply talking about the 5 states, and it's Tennessee, Connecticut, I can't remember the other 3 off the top of my head, where you just must disclose information your client may cause harm, that is not necessarily related to any criminal or fraudulent thing, so you don't trigger the withdrawal or those other things. So it kind of really depends on which part you're in. So I guess the answer to your question is, if I'm in a state that says even if my client's obeying the law and they're emitting more than X thing, I need to say to the world, and who am I disclosing to, by the way? Yeah, my client's killing people. There, I've said it. Doesn't bother me. I'm still representing them. Attorneys for TVA, anyone? They're moving in the right direction. So I think that's the issue. And each of these questions points up, in some ways, again, the potential absurdity of this, right? It seems so disconnected and a bit far-fetched, and yet all it takes is one state Supreme Court or Attorney General to say, oh yeah, yes.
But then let me just ask you a follow-up. In those 5 states, if you've got a facility that's complying with RCRA to the letter, but is basically generating, a RCRA hazardous waste and presumably putting it somewhere, isn't that creating a risk of harm?
So not to get into an argument about RCRA and CERCLA, but I will. So if you're complying with RCRA, any waste that is declared hazardous, which by definition is something that could cause harm, death or substantial bodily harm, will not be released into the environment, period.
I'll quibble with that.
Yes, but it's kind of a definitional thing, and the same with like Section 7 under RCRA for an immediate cleanup or CERCLA. If it's harmful, then it causes death or substantial bodily harm. If you clean it up correctly, it does not. I mean, even though we know that's not exactly true.
Well, but then the ironic, not ironic, but then the interesting solution to the ethics problem is to create federal standards for greenhouse gas.
Well, and query whether, one of the differences between greenhouse gas governing strategies and every other pollutant we've ever dealt with before is if you look in the United States, we've always drawn the line at where we stop pollution, at least normatively, if where it causes harm to human health and the environment. So again, definitionally, normatively, if you're in compliance with all of this suite of laws, you're quote unquote not hurting anybody. We know that's not true, but that's by definition the way the law is set up. Climate change, on the other hand, we don't have a law here, but even the international standard is not set at, or the proposed international standard is not set at a point where no one is harmed, right? It's a cost, they've done some kind of cost-benefit analysis to get to the target even before. So that makes it sort of different in this case than our traditional pollution control laws. Yes, in the back, I'm sorry.
Anybody who teaches here has to take up environment with their coffee. But I teach ethics.
Okay, oh good, I'm glad, thank you.
I have some former students in this class, and some of them I hope are sitting thinking, wait a minute, we had a problem in our book, and I'm the author where we address these issues, not from an air issue.
Right.
I get what you're talking about.
Exactly, yeah.
But I would fix the teacher's manual that Activism. But what happens if you're asked to write an opinion letter? And you use word for EPA, you've got some information. What if the damage is to dogs as opposed to people, which is a great discussion with this
Right.
and what about the reporting requirements that other lawyers have?
Oh, to report.
Let's say
That's huge.
that's huge.
That is another triggering thing that makes this more likely than it would otherwise be.
Well, this is, I think we're seeing the next headline of, I'm not sure where it's going to be reported, but in the next year, this is going to happen. At least more than once. I agree with that. This is marvelous. And I will tell one story, though, because it also feels a little weird, but 35 years ago, I supervised a student working for a large and nameless organization that had hazardous waste that they tended to sell to people who then they just dumped it on the ends of small roads. And the student went to her supervising attorney and said, I'm concerned about this. And long story short, because of the ethics rules, this big company changed its stuff to ethics. So you are
I would love to get that example too. All right, thank you. Thank you very much. Yes, and that is an important part of it. I don't know if that was clear, that most attorney ethics state, in fact, probably all of them, even know this, I don't, that if you suspect another attorney of violating ethics violations, you have to report that. Yeah, right. So, so that leads sort of another path that where this might come up. Yes?
The question you asked, but I didn't hear the answer, is who should we be reporting to?
Exactly. Well, so you have to go back to the reason the reporting is either required or allowed, which is to prevent death or serious bodily harm. So who does the reporting to stop that death or substantial bodily harm, right? If you report to the EPA in the current frame that this person didn't report their emissions, so what, right? Does that mean they're going to do anything about it or not? Well, maybe. Because the very act of the reporting makes it subject to generally public disclosure. And the point of this, at least for the violation of how much you're, now we're not even getting to like the really bad actors who may be doing secret things, right? We're not even talking about that. Or secret, like emitting all kinds of greenhouse gases that they know are bad and they don't tell anybody or whatever. But imagine, if you will, so the way I think about this, let's use the example of methane. Let's say you're a company that does fracking, right? I don't know if you all know, there's been a large dispute in the last maybe 3 years about exactly what percentage of methane is leaking at the fracking site, and some differentiation between like majors versus independents and this and that. And everybody's using parts of these studies to make their arguments for and against regulation, et cetera. Well, what if your client, I won't mention a name, you know, has, which is probably likely, some more specific, very site-specific studies about emissions that haven't come out because the proposed regulation of those things has been slowed. You find that out. You know, it matters if you're a major fracking enterprise in the Permian Basin whether you're leaking at 1% or whether you're leaking at 5%, right? That's enormously impactful. And so the fact that you report it, maybe just reporting in a way that it can get to the press, the public. I mean, I know that's, again, another odd thing about this, and yet I sort of feel like we're on the cusp of that as a possibility. Well, it's 5 till I have to go teach class, too. So thank you all for coming out. I appreciate it.